President of the Nigerian Bar Association, I acknowledge your very efforts. Congratulations. Because the time is far gone, I have a written paper. As much as possible, I'll try to guillotine. Firstly, let me appreciate and thank the organizers of this auspicious talk shop. The team are very dear and crucial at this very important moment in our nascent democracy. The theme of the 2025 discourse is Strengthening Local Government Autonomy, a dialogue on the impact and implementation of the Supreme Court judgment. It is assumed, albeit erroneously, that the particular judgment of the Supreme Court of Nigeria, the sinecure of this year's theme, is known to all, including the organizers and the participants. My guess is that the particular judgment we have in mind is the one said to have declared the financial autonomy of the local government in Nigeria. And it is the suit number SCCV 343/2024, the Attorney General of the Federation and the Attorney General of Abia State and 35 others. This is the first bold step ever taken by the Attorney General of the Federation to bring to bear or to try to enforce a particular provision of the Constitution that will support the nascent democracy we are participating. Autonomy presupposes independence, freedom, liberty, self-determination, self-government, self-rule, or sovereignty. The antonym of autonomy is dependence, appendage, or the state of being subservient. Hither to the recent decision of the Supreme Court on financial autonomy of the local government in Nigeria, the issue had been whether state functionaries can exercise powers to suspend, dismiss, or dissolve democratically elected local government council, including the chairman, vice chairman, or the councillors. The question had always turned on the interpretation of Section 7, Subsection 1 of the 1999 Constitution, which I reproduced. The Supreme Court had consistently struck down the provisions of the various state local government laws empowering the governor to suspend, dismiss, or dissolve a democratically elected local government council, and in the state, appoint transitional or caretaker committee to run the affairs of the local government. Take, for instance, the Supreme Court decision in Ajuon against Governor of Oyo State in 2021 that struck down sections 11 and 21 of the Local Government Law 2001 of Oyo State that empowered the state governor on the recommendation of the House of Assembly to dissolve and dismiss elected local government council, including the chairman, vice chairman, and the councillors, and replace them with his handpicked men to run the affairs of the local government. The court took similar stance in previous decisions: Attorney General of Benue State against Umar, Attorney General Plateau State against Guyur, Eze against Governor of Abia State, Governor Ekiti State against Olubumi. They are all there in the law reports. In all the above cases, the court took a position in effect that the existence of the provisions like sections 11 and 21 of the Local Government Law 21 of 2001 of Oyo State posed real and existential threat to the system of democratically local government guaranteed by section 7.1 of the Constitution, the intent of which is to vouchsafe the inviolability of the sacred mandate which the electors at the local grassroots level democratically donated to the local government chairman and the councillors. In Ajuon, the governor of Oyo State, and the governor of Oyo State, it was stated poignantly that the local governments are neither mere appendages nor parastatals of the state. And it appears the governors seem to take the position that they are mere parastatals which they can willy-nilly deal with and even tamper with their funds. The question, why are these our democratically elected governors constituting themselves into a body of anti-democracy species most dangerous to the constitution and democracy in Nigeria? MBA and our jurists must find an answer to this question. Again, why are the governors, notwithstanding the avalanche of decisions of our law courts, including the Supreme Court, still adamantly being recalcitrant and unyielding to upholding the Constitution and the rule of law, a major covenant in their oaths of office, which they respectively subscribe to before taking up their various offices? What do we do with the attorneys general who counsel the governors to flout the Constitution and desecrate the rule of law? The financial autonomy. In the aforesaid Attorney General of the Federation against Attorney Generals of the 36 states, the plaintiff, the Attorney General of the Federation, raised the 8 and 9 sought the court in substance to hold that the failure of the states to organize elections and put in place a system of democratically elected local government councils in their respective states was an act of dereliction of constitutional duty, and that the system of self-serving caretaker committees put in place by them to administer the local government was unconstitutional and illegal. The court had no difficulty in answering the questions in agreement with him, particularly in view of the subsistence of some of the earlier decisions, including the earlier mentioned ones. It may also be added that it amounts to the dereliction of the constitutional duty for a governor or any other state functionary to refuse to perform a constitutional duty imposed on him. It amounts also to abuse of office, contrary to paragraphs 1 and 9 of the Code of Conduct for Public Officers in Part 1, the 5th schedule to the Constitution. For a public officer, including the governor, to do or direct to be done anything arbitrary, any arbitrary act prejudicial to the rights of any other person, knowing that such an act is unlawful and contrary to government policy. Paragraph 18.2 of the same 5th schedule provides inter alia that the punishment which the Code of Conduct Tribunal may impose for abuse of office in violation of the Code of Conduct for Public Officers shall include A, vacation of the office or seat in the Legislative House, or as the case may be, disqualification from membership of a Legislative House or from any public office for a period not exceeding 10 years. You may, for purposes of interpretation, the question in paragraph 18, the question is whether it also includes the governor, but that's a different matter altogether for now. Issue 7 imposed by the plaintiff is whether a state in breach of Section 7 and 162, 5, and 6 of the Constitution is entitled to receive and spend funds meant for the local government council while in breach of the Constitution for not putting in place a system of democratically elected local government council. The answer was emphatic no by the Supreme Court. The substance of issues 11, 12, 13, 14, and 15 posed by the plaintiff includes whether, on account of the state failing or refusing to put in place a system of democratically local government councils, the state has unbridled and unrestricted discretion to operate state joint local government account whimsically to the disadvantage of the local government, whether by virtue of Section 162, subsection 6 of the Constitution, the state is not an agent of the local government in the collection of the amount standing to the credit of the local government. The Supreme Court did not mince words in the declaration that all amounts standing to the credit of the local government from the federation account and to the state belong to the local government and is therefore entitled to be so paid. The point was further reiterated by the judgment by the Supreme Court in the judgment that by Section 162, subsection 3 thereof, the Constitution does not intend joint ownership of any amount standing to the credit of the local government from the federation account, and the state. And the state and the local governments are each entitled to the amount standing respectively to their credit from the federation account. The Constitution does not intend that the state shall retain the money distributed to the local government constitutionally as the third-tier government, and that the state's unilateral retention of the money meant for the local government from the federation account is illegal and unconstitutional. In other words, the state, by virtue of Section 162 of the Constitution, has no right to withhold, hold, or retain any money belonging to the local government. The judgment, therefore, has stated the position or the financial autonomy of the local government qua the state poignantly and beyond reasonable doubt. Much as we hail the Supreme Court for this local government financial autonomy judgment, the next question that needs to be asked is whether the learned justices of the Supreme Court had not unwittingly amended or rendered moribund and or inoperable Section 162, subsections 5 and 6, which provides that 5, any amount standing to the credit of the local government in the federation account shall be allocated directly to the state for the benefit of the local government councils on such terms and in such manner as may be prescribed by the National Assembly. But I'm aware that the National Assembly has not made any act to this effect. Subsection 6, each state shall maintain a special account to be called state joint local government account, into which shall be paid such allocations to the local government councils from the federation account. And if indeed the Supreme Court had unwittingly and inadvertently, as the critics are suggesting, amended the Nigerian Constitution by the subject local government financial autonomy judgment, will the judgment not be a killjoy on a simple fact that the Supreme Court had outrageously assaulted the very Constitution that it was upholding, a malfeasance that is forbidden of the court to so do? Nothing in the Constitution permits the Supreme Court to legislate, and it is ultra vires the court to amend the Constitution or any other statute, or by its own decision render inoperable any statutory provision. The function of the local government, the function of the court is simply jurisdictory, not to make laws. They have no constitutional right to amend or to add to any statute, including the Constitution. There's nothing like judicial legislation or legislative judgment in the judicial powers vested in the Supreme Court, like any other law court under our Constitution. Issue 10, raised by the plaintiff, is to the effect that whether the governor or any other state official who may have illegally caused or directed the dissolution of a democratically elected local government council could be liable to be prosecuted either during or at the end of the tenure, as the case may be, for criminal offenses bordering on breach of Constitution and or contempt of court, or any other criminal or penal laws was not answered. And that was because it was hypothetical, just as it was seeking the court's advice. Nigerian courts do not entertain hypothetical questions. They also have no advisory jurisdiction, unlike the Supreme Court of India. And earlier in this paper stated, and it was not in the subject judgment of the Supreme Court, that abuse of office is a serious public offense in the 5th schedule to the Constitution, the Code of Conduct for Public Officers. The jurisdiction to try any person for the offense, for the said offense, resides and is vested in the Code of Conduct Tribunal. It appears it does not avail a governor to plead his immunity, which is a debatable question, under Section 308 of the Constitution. Does it not sound unreasonable for the man violating the Constitution to plead his cover in its shredded form? St. Paul of Tarsus in the New Testament, in the Holy Bible, says, reasoned, he who does not acknowledge the law shall be adjudged without it. The Supreme Court of Nigeria, in Asari Dokubo, against the Federal Republic of Nigeria, 2007, had attempted to answer this question at page 38 of the Ligapedia.
Law Pavilion, electronic version, page 38, IT Mohammed JSC, then as it was. He appears to concur in the jurisprudence while dismissing the bail application of Asari Dokubo, who was standing trial for treason, that where national security is threatened or there's real danger of it being threatened, human rights or individual rights of those responsible must take second place. Human rights or individual rights must be suspended until national security can be protected or well taken off. He goes on, this is not new. The corporate existence of Nigeria as a united, harmonious, indivisible, and indissoluble sovereign nation is certainly greater than the citizens' liberty or right. Once this security of the nation is in jeopardy and it survives in pieces rather than in peace, the individual's liberty or right may not even exist. It follows from this argument, therefore, that the state governor whose physical banditry being the ulterior purpose of his violating the Constitution as well as renouncing the covenant in his oath of office to eschew corruption and to protect the Constitution, cannot and should not be had to invoke his immunity under Section 308 of the Constitution if and when he is charged or arraigned before the Code of Conduct Tribunal for trial upon information of abuse of office contrary to paragraph 9 of the Code of Conduct for Public Officers in the 5th schedule to the Constitution. Was that supposed to be noticed to me? Okay. Is it not time we limited the scope of the constitutional immunity for the state governor since it is not serving any useful or functional purpose as incumbents are abusing and or resorting to this umbrage to commit all manners of maliciously criminal malfeasance, including unbridled corrupt practices that undermine the interests of their subject or citizen? For how long will our constitutional law remain an ass, doing nothing to prevent and punish the malignant evil to the society it was erected to guide, guard, and protect? For now, the bad boys are the state governor, who will lay and misuse the funds of the local government coming from the federation account. Is it not early to shout to Eureka? Since power corrupts and absolute power corrupts absolutely, we should now be thinking ahead on how to check the physical powers of the so-called executive chairman timelessly, if the financial autonomy of the local government is anything worth celebrating. And what about the lawyers whose humongous bills for election petitions are, to your knowledge, paid by the governor through the office of the Attorney General from the money stolen from the local government account? Are you not in pari delito in the sordid and unwholesome practice? A person who participates criminally should also share in the guilt and the punishment for the offense committed, at least as a conspirator. As Jesus Christ would have scribbled on the sand and told the lynching party, only he who had not committed an offense should cast the first stone on the adulterous woman. My learned friends, we cannot effectively fight this cause unless we inculcated in ourselves the principle of equity, insisting that we cannot come to equity with soiled and unclean hands. This should be my last word on it. And thank God the bell is telling me to shut up.